Hello everyone. Today we will do Laxmikant's third chapter, Silent Features of the Constitution. All right. This is another important chapter which is very important for your any kind of services examination which you are preparing, and it is quite useful in the general knowledge perspective as well. Some silent features are here. It is told. All right. Now, some things have been given here. Particularly 7th, 47th, 44th, 73rd, 74th, 97th, and 101st amendments took place. And the 42nd Amendment of 1976 is known as the mini constitution due to the importance and large number of changes made by it in the various part of the constitution. All right, that means uh, the 42nd Amendment of 1976 is known as mini constitution since it changed lots of the articles and parts, not the parts but the articles. It brought some changes in the constitution. However, in Keshavananda Bharti case of 1973, the Supreme Court ruled that the constituent power of Parliament under Article 368, remember Article 368, does not enable it to change the basic structure of the constitution. That means the basic structure of the constitution cannot be changed or hindered in anyhow. All right. And when the Supreme Court said that in the Keshan Bharti case in 1973. Now, some silent features of the Indian Constitution is it is the lengthiest written constitution. All right, and originally in 1949, the Constitution uh, contained a preamble, 395 articles divided into 22 parts and 8 schedules, and presently it consists of preamble, 470 articles divided into 25 parts and 12 schedules. That means two new schedules have been added and three new parts added. We still have the preamble and almost 100 articles added. Earlier we had 395 articles and presently we have 470 articles. There are around 65 articles were added. All right. So let's move forward, and we have the four factors of the contributed to the elephantis size of our constitution. They are geographical factor, this is vastly known as the country and its diversity. Historical factor, that is influence of government of Indian Act of 1935, which was bulky, and a single constitution for both center and state, and dominance of legal immunities in the constituent assemblies. So these are the four factors due to which India's constitution is of elephantis size. That means India is a large place geographically as well and historical as well, due to the Britishers rule. We had number of constitutions, sorry, not constitutions but acts and regulations which affected the constitution, and it is single constitution for center as well as state, and there was lots of legal dominance of lawyers and politicians, so it has to be bulkier. All right. So another is that it's drawn from various places. So it is quite true that it has been taken from various places, and Dr. B.R. Ambedkar ransacks almost all the known constitution of the world to form a better constitution. And the structural part of the constitution is to large extent derived from the Government of India Act of 1935, and the philosophical part of the constitution, the fundamental rights and the directive in the state policy, derived from the inspiration of America and Ireland. Okay, that means the Irish constitution. They have been taken from that respectively, and the political parts of the constitution, that is the principle of the cabinet government and relation between the executive and the legislature, has been taken from the British constituencies. And then we have also taken certain things from Canada, Australia, Germany, USSR, which is now Russia, France, South Africa, Japan, and so on. We'll talk later on about it. And the most profound influence and material sources of the Constitution of Government of India 1935, federal schemes and judiciary government, emergency power, and the public safety and everything has been taken from different types of constitutions whatsoever. And it is a blend of rigid and flexibility. That means in somewhere we will find the rigidity, and somewhere we will find the flexibility. A rigid constitution is the one that requires a special procedure for its amendment, right? For example, if you take the example of American constitution, it requires lots of special procedure to amend the constitution, while the flexible constitution on the other hand is one of the one of the constitution which is amended at the same manner as the any ordinary law it is taking place, just like British constitution. It is very flexible in nature. All right. And the Constitution of India is neither rigid or not flexible, but it's a synthesis of both. Article 368 proved to be two types of amendment. That is the Article 365, which gives power to the Indian Parliament to make laws, right? To change or amend anything in the Constitution, but it cannot change the basic structure of the Constitution as per the Keshav Nandi Bharti case. All right. And some provisions can be amended by the special majority of parliament, right? That means a majority can be done, special majority can be done if they want to do it. That means two-third or majority required of members of each houses, and house present and voting. That means those who are present and those who are voting, and a majority of total membership of each house is also required. Now, some other provision can be amended by the special majority of the parliament, and with ratification of half of the group of the states. That means if some things wants to get amendment, they can be amended like an ordinary laws as well. Some provision of the constitution can be amended by the simple majority of the government manner of ordinary legal provisions. Notably, these amendments do not come under Article 368. That means if some amendments are taking place, they won't be coming under Article 368 because it gives the special power to the parliament to change the constitution, but not the basic structure of the constitution. So, if we move forward with the federal system with unitary bias, that means both center and state rules, but ultimately the state or the unitary bias, it is quite unitary bias. All right. So there's nothing wrong in it. It has to be unitary bias to uphold the nation. Well, the Constitution of India established a federal system of government. It contains all usual features of the federalism, like two government division of powers, written constitution, right, and rigidity of constitution and supremacy of constitution, independent judiciary and bicameralism. It all has all the type of things. So it is quite federal in nature. However, Indian constitution retains a large number of unitaries and non-federal features a strong center. It has a very strong center and single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state government, central as well as the All India service. All right. So it is a blend of both the rigidity and flexibility, as we have already told, but uh, uh, it is also pertaining unitary biasness, but also promoting uh, the flexibility and the federal system of the government. That means it has a two governments, division of power, written constitution, supremacy of constitution, rigidity of constitution, right, independency, judiciary, bicameralism, but on the other hand, it also has a strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state governor by the center, all India services, emergency provision, and so on. However, the term federation has been used in the Constitution Article 1. On the other hand, describe as India as a union of country. All right, India is a union of states. It is not some federation like US. All right, and it implies that two things. What it implies that the Indian Federation is not the result of any agreement by the state, which they did in the US, and no state has the power to get away from this union. All right, and Indian Constitution has been variously described by the federal form of unitary spirit, quasi-federal by K.C. Well. So this is K.C. where bargaining federalism by Morris Jane, Morris Jones, and cooperative federalism by Granville. Cooperative federalism in Granville, while uh, quasi-federal by the Casey Ware, and unitary in spirit. All right, federal in form. It is quite federal in form and unitary in spirit. Right, okay, so it's quite given good sorts of thing. And Austin and Graver Austin, right? And the Federation with Central Tendency. Okay, Federation with Central Tendency by Evan Jennings. Now, the parliamentary form of government, the parliamentary system is based on the principle of cooperation and coordination between the legislature and that means legislature as well as the executive will be cooperating and coordinating in between themselves to deal with the presidential form of government, while the presidential system is based on the doctrine of separation of powers between two organs. Right. So Now, the parliament is also known as the Westminster. The parliamentary system is known as the Westminster Model responsible for the responsible government or the responsible government or the cabinet government, and the constituent system is the whatsoever. Well, features of parliamentary form of government: the presence of nomination and real executive. That means it has a nominal and real executives, a majority party rule, and collection responsibility with executive to the legislature. That means the executive is responsible to the legislature, member of the minister in the legalization, leadership of the prime minister as the chief minister or the chief minister, and dissolution of the lower house or the Lok Sabha or assembly. Right? Synthesis of parliamentary sovereignty and judicial supremacy. All right. And the Supreme Court, on the other hand, is declared that parliamentary laws are unconstitutional, though its power and judicial review. Right. The parliamentary, on the other hand, can amend the major portion of the constitution through its constitutional power. That means the parliament can amend major portion of the constitution if it requires to do it, while the Supreme Court, on the other hand, declares that the parliamentary laws are quite unconstitutional, though its power judicial review. All right, because the judiciary, the Supreme Court, has the power of the judicial review. So it can the Supreme Court can always term any parliamentary laws as unconstitutional because of its judicial review system, while the Parliament can amend any major portion of the Constitution through its constitutional power. Right, integrated and independent judiciary. We have a integrated and independent judiciary. That means there is no dependency of the judiciary, though judiciary's form is a part of our constitution. All right, the Supreme Court stands for the top of the integrated judicial system in the country, but below the High Court, and then the state level under a High Court, there's a hierarchy of subordinate courts, district courts, and other lower courts. While the single system of courts enforce both central laws as well as the state law. The Supreme Court is a federal court, the highest court of appeal, and guaranteed of fundamental rights of the citizen and guardian of the Constitution. Hence, the Constitution has made various provisions to ensure its independence, security, and tenure of judges, fixes of services, condition to judges, all the expenses of the Supreme Court charged on the Conservative Fund of India. That means the expenses. That means uh, the tenure of judges, the fixed services, all right, these all things, while the expenses of the Supreme Court, charge of the Consolidated Fund of India, means they have been taking it from the Consolidated Fund of India. Remember it. And prohibition on discussion of the conduct of judges in the legislature, ban of these practices after retirement, power to punish for the contempt vested of Supreme Court, separated of the judiciary from executive, and so on. These all things have been there. Now we have the fundamental rights. All right, we in the Constitution as a silent feature we have the fundamental rights. Part three deals with it. We have the right to equality, freedom against exploitation, freedom of religion, culture, education rights, and right to constitutional remedies. So these are the fundamental rights which are given to every citizen of India, and these are injustible in nature. There is enforceable by the court for its vocation, and aggregated person can directly go to the Supreme Court if it's right. We'll talk about it later on, but any kind of person who thinks that he has been deprived from fundamental rights, it can directly go to the Supreme Court for its uh, any type of legal issues, and Supreme Court can also issue several writs like habeas corpus, mandamus, prohibition, statutory, quo warranto for the restoration for his rights. Right, so these all things can be done. All right, these all things can be done, and later on when we'll study about the judicial system of India. However, the fundamental rights are not absolute. That means if fundamental rights are not done, we can't go to court directly based on that it has been right. Earlier we had right to property as well, right? Article 31, but it was later removed by one of the constitution amendment in 1978, right? However, to reasonable restrict further, they are not sacrosanct and can contain or repeal by the parliamentary through a constitution amendment act. All right, that means through parliament it can be amended, but and these are also suspended during the operation in national emergency except the right of guarantee. All right, so Fundamental rights can also be suspended during the emergency, except the right guarantees by the Article 20 and 21. All right, and we have directive principle of state policy as well. And B.R. Ambedkar also said that directive principle of state policy is a noble feature of the Indian Constitution. Right? There are emergence of Part 4 in the Constitution. They classified into broadly categories like social, Gandhian, and liberal intellectual. All right, and DPSP are meant for the promotion of idea of social and economic democracy. They seek to establish a welfare state in India. However, unlike the fundamental rights, the directives are non-justiciable in nature. That means the directives are non-justiciable in nature. Justice cannot be done. But while the fundamental rights are justiciable in nature and they are not enforceable by the courts on their violation. All right. Fundamental rights are promoting the idea of democracy, the operate limitation of tyranny, of regulation. All right, they are justiciable in nature. These are justiciable in nature, while they are enforceable by the court for its violation. So, if their violation took place, they can you can move to court. But in DPSP, you cannot move to the court. Yet the Constitution itself declared that these principles are fundamental in the governance of Constitution, and shared that the duty of the state of applying the principle makes it law, and they impose a moral obligation on the state authority for its application. Right? We have fundamental duties. These are added by the operation of the integrated emergency during 1975 to 74 by the 42nd Constitution Amendment of 1976 on the recommendation of Soren Singh Committee. Remember, Soren Singh Committee is related to which? The fundamental duties. All right. Then we have the 86th Constitution Amendment Act of 2022, which was one more fundamental duties was there. All right. It was added, one more fundamental duty was added. All right. Part 4A. The Part 4A of the Constitution, which consists of only Article 51A, specifically enslaves that the fundamental duties is to respect the Constitution. That means we have to respect the Constitution, national flag, and national anthem to protect the sovereignty, unity of the country, to promote the spirit of Commonwealth brotherhood among the people of India, to preserve the rich heritage and composition of the culture, and so on. And however, this directive principle, thus the duties are also non-justiciable nature. That means they are non-justiciable nature. You cannot go to the court if they are violated. Then a secular state is demanded in the Constitution of India. It does not uphold any particular religion of the Constitution. Official religion of the Indian Constitution. The following provisions are the Constitution repealed by the intellectual character of the Indian state. While the 42nd Amendment, 42nd Constitution Amendment Act of 1971, it added the word secular, right? And in the preamble of Indian Constitution. All right, by the 22nd Constitution of 1971, the preamble secure all citizens and liberal of belief, faith, and worship. The state shall not deny any person equality before the law and equality protection of law. The state shall not discriminate against any citizen based on their religion. Equality of the opportunities for all citizens in matter of public employment. All citizens are equally entitled to freedom of conscience and right to freely profess the practice and propagate any religion. Every religion dominant on any or shall be have right to manage their own religious affair. No person shall compel to pay tax from promotion of particular religion. No religion instruct shall be provided in any education institution maintained by the state. Any section of the citizen shall have the right to conserve its distinct language, the script, or the culture. All minorities have the right to establish and administer education institute of their choice, and the state shall endeavor to secure for all citizens in uniform civil code. All right. This negative concept of secularism is inappreciable in the Indian situation, where the society is multi-regional, religious. However, the Indian Constitution embodied that the positive concept of secularism, that is the given equal respect to all religion and protecting all religion equally. Universal adult franchise. All right. Then we have the universal adult franchise again. Every citizen who are less than 18 years of age has a right to vote, doesn't have the right to vote, and without any discrimination of caste, case based on wealth, and so on. And the voting age was actually 21, but it was reduced to uh, it was later reduced by the Rajiv Gandhi government in 1988 uh, by the 64th Constitution Amendment. All right. And then if we move forward, we have single citizenship. All these states have one citizenship, whether they belong to center or state. Unlike the US, where two citizens are required, first of the Americas, and another one is of the states. In India, all states, all citizens enjoys one citizenship. All right, and we have the independent bodies like Election Commission is there. All right, and we have Controller and Auditor General of India, or these are not dependent on the any type of government. All right, we have the UPSC, Union Public Service Commission, and we have the State Public Service Commission also. And then we have the emergency provisions also. All right, these can be done at the time of required to safeguard the sovereignty, unity, integrity, and security of this country. And the democracy political system are the constitution one. We have the three types of emergencies listed in our constitution. First is the national emergency. Second one is the your state emergency, and third one is the financial emergency. National emergency is under the article 352. State emergency article 356. And then we have this article 360 for the financial emergency. Now there is also article 356 and article 365. Now let's understand it, though we'll further read it detail. National emergency on the ground of war or external aggression or armed rebellion. At that time, national emergency will be declared. The state emergency is also known as the presidential. All right, and this is a ground of failure of constitution machinery in the state, that is in Article 356, or failure to comply the direction of the center, Article 365. Then we have the financial emergency on the ground to threat for the financial suitability or credibility of India. During the emergency, central government becomes fully powerful, and state goes to total control of the center, and it converts the federal structure into the unitary one without any formal amendment of the constitution, right? And this kind of transformation of political system of federal normal times to the unitary emergency is a unique feature of the Indian constitution. That means the transformation taking place from the completely federal to the unitary look. Then we have three-tier government, the central, state, and the local bodies, and it was added by the 73rd and the 74th Constitution Amendment of 1992, and it added the three-tier system of the government. That means we have the local government as well, which was added, and which is not founded in any other constitution of the world. That means three-tier government system is not available in any of the constitution. We have the 75th Common Act of 92 gave the constitution recognition that the rural local government by adding the part 9 into it. All right, and the new schedule 11 to the constitution. Similarly, 74th of the constitution gave the recognition to the municipalities also given. And as per the 74th Constitution 1992, while the 73rd gave the panchayat rule, that means the rural local areas, and municipality came to the urban local areas by adding a new part 9A and a schedule. All right, 9A was added in a new schedule of 12 to the constitution. Then we have cooperative societies. By the 97 Constitutional Amendment of 2000 gave the constitution stature and the protection of to cooperate the societies. It made the right to form cooperative society and a fundamental rights. All right, means anybody can form a cooperative society as a fundamental right. And Article 19 is then given. Include a new directive principle of state policy on the promotion of cooperative society in Article 43B. That means it is also it is also directive by the constitution to the any present government to have to promote the cooperative societies. And then a new part 9b's constitution has been entitled to the cooperative societies, article 3. These all things are given. Okay, we don't have to read it all. Then we have part 9b, that means ensuring the cooperative societies, and it empowers the parliament to respect the multi-state cooperation society and the state legislature in respect of other cooperative societies to make appropriate law. Then we have further criticism to the constitution. Some people say that it's a borrowed constitution. So definitely it's a borrowed constitution, mainly from Government of India Act of 1935, which we have discussed in the previous lectures. And it is a borrowed constitution, a bag of borrowings, a hodgepodge constitution, a patchwork of several documents of the world constitution. The criticism is unfair and illogical. Why? Like, because we never took everything, copy paste everything, right? We modified as per our own conditions, and that's what the Dr. Ambedkar also said, that nobody has right copyright over their constitution. And some people say it is a carbon copy of 1935 Act. So it is quite true. But one of many people that like N. Simran observed, right? Carbon copy of 1935, amended version of the 1935 Act. For example, N. Srivastava observed that the Indian Constitution, both language and substance, are close to Act of. That means in language as well, and in the substance as well. It is quite close to 1935. Then 1935. Then Sir Ivan Jennings, it constitutes derived directly from the Constitution of India. All right, and we have it is provision are copy almost textually, means everything is copied. And we have P.R. Deshmukh, and he told that the constitution is essentially the government of India Act of 1935 with one adult franchise added. And Dr. B.R. Ambedkar said that nobody holds any parent rights in the fundamental ideas of the constitution, right? Some people say it is un-Indian or anti-Indian. It does not reflect the political traditions and the spirit of India. As K. Hanumanthaya, we wanted the music of Veena or Sitar, but there was the music of English band. That means he wanted that our constitution should be written in Sanskrit, and but it was completely made in English, right? And Loknath Mishra said that the it is an imitation of West, much more a slavish surrender to the West. Then Lakshmi Narayana Sahu said that it is not prove it will not the constitution will not prove suitable and would break down soon, though it never happened. And some people say it is un-Gandhian constitution. How? K. Hanumanthaya said that it is exactly the kind of constitution Mahatma Gandhi did not wanted and did not envisage it. Then T. Prakasanam said that the attributed this lapse to amendments non-participant in Gandhian movement and antagonism towards the Gandhian ideas. That means Ambedkar was against the Gandhian attitude. Then elephant side, it is too bulky, and Sir Ivan Jennings said, all right, that it is quite too long and complicated. Then H.P. Kamath said that the emblem and the crest that we have selected for our assembly is an elephant, and it is perhaps the concerns with our constitution is too bulkier than the world has produced. And I'm sure the house does not agree that we would make the constitution an elephant in size one. Then it is the paradise of lawyer. The Indian constitution is too legalized, legalistic, and very complicated. Sir Ivan Jennings said that it's a lawyer's paradise. H.K. Maheshwari said that draft tend to make people more litigious, more inclined to go to law court, less truthful and less likely to follow the methods of truth and non-violence. All right. Then P.R. Deshmukh said it is a ponderous torment of law manual, and it is quite verbiage, right? So here the Constitution of India at glance has been given: the Union of Territory from Article 1 to 4, citizenship, fundamental rights, directives of state policy, fundamental rights. Then the Union has been given, and what contains of the Union, what is the part and significance of the Union has also been given. Then the state government has been talked about, and the state government in Part B of the first schedule is all, which was later deleted, right? This was deleted. Then the union territory, the panchayat, municipality, the cooperative society, the scheduled caste, scheduled areas, right? Relation between union and the state, and the financial property, contract and suits, then trade, commerce and intercourse with the territory of India, the services under the union and the state. And then we have the tribunals, the elections, special provision related to certain classes, official language. We have the emergency provision, then some miscellaneous amendments to the constitution, the temporary transition of the special provision, then short titles, commencement and authoritative text. Then there are some further very important articles have been given, so I'm not going to read it out completely because it will take lots of time, which can be read it out completely. All right, and it is quite. We will read it about when we'll discuss about the chapters. Then schedule. It's quite important. The schedules of number first schedule is about the names of states and their territory, judiciary, the name of the union territory and their extent. It covers in Article 1 and 4 first schedule. Now, second schedule deals with 59, 65, 75, 97, and these all constitution. It provision related to the enforcement, allowance, privileges, and so on. The President of India, the Governor of India, the Speaker and Deputy Speaker of the Lok Sabha, the Chairman of Deputy Chairman of the Rajya Sabha, the Speaker and Deputy Speaker of the Legislative Assembly in the state, the Chairman and the Deputy Chairman of the Legislative Assembly, then the judges of Supreme Court, the judges of High Court, the Controller and Auditor General of India, it forms oath and affirmation as per these articles which have been given. The union minister, the candidates of the elected to the parliament, the members of constitution, the judges of supreme court, the controller and auditor general of India, all right, the judges of Indian courts. The fourth schedule, allocation of seat in the Rajya Sabha to the states and the union territory, then covered in 4 and 80. Fifth schedule is about Article 244, provision related to the administration control of scheduled area and scheduled tribes. Sixth schedule was provision related to the administration of tribal areas in the state of Assam, Meghalaya, Tripura, and Mizoram. Article 244 and 275. Then we have seventh schedule, division of power between the union and state in terms of list 1, that is union list, list 2, that is the state list, list 3 is as the concurrent list. Presently, the union list contains 98 subjects, originally 97, and the state consists 59, originally 66, and the concurrent list is 52 subjects, originally 47. Then we have the 8th schedule, the languages recognized by the constitution. Originally it was the language, but presently there are 22 language, and these languages covered in Article 344 and Article 351. We have Assamese, Bengali, Bodo, Dogri, that is also not Dongri, Gujarati, Hindi, Kannada, Kashmiri, Mongali, Mathili, Meghalaya, Manipuri, Marathi, Nepali, Odia, Punjabi, Sanskrit, Santhali, Sindh, Tamil, Telugu, Urdu. Sindhu was added in the 21st, Sindhi was added in the 21st Constitution Amendment of 1965, 1967, sorry, and Konkani, Manipuri were Nepali were added. These were added in the 71st Constitution of 1992, and Bodo, Dongri, Mathili, these are added by the 92nd, 92 amendment of Act of 2003, and Odia was named as Odia in 96 Constitution Amendment. Right? We have the ninth schedule, Acts and Regulation, originally 31 and 31B, and presently these are presently uh, all right. And state legislative evolution of the zamindari system. Then we have the parliamentary. The schedule was added in the first. The schedule was This schedule was added by the First Amendment 1951 to protect the laws, included the judicial scrutiny, ground violation, fundamental rights. However, 28th Supreme Court has been given. Then schedule about the provision of disqualification of members of parliament, state legislature on the ground of deflection, and this schedule was added by the 52nd Amendment of Constitution in 1995, and it is known as anti-deflection law, which was introduced by the Rajiv Gandhi government. And we have the 11th schedule, which is known as the specific powers authorized by the panchayats and 29, on the basis of 29 matter, and this was added on 73rd Constitution Amendment of 1982. Along with that, municipalities was also added, which was this by the 74th Constitution Amendment of 1992. It has 18 matter in hand, while the panchayat has the 29 matter in hand. All right. So this was all about the schedules. Now we will talk about the sources of the constitution at glance. All right. We have the Government of India Act based on 1995. What we have taken, the federal scheme, the Office of Governor, Judiciary, Public Service Commission, based on Commission, and we have the emergency provision and administrative details. Right, we have British Constitution. We take the parliamentary form of government, the rule of law, legislative procedure, single citizenship, cabinet system, prerogative writs, parliamentary privileges, and bicameralism. From the U.S. Constitution, we have taken fundamental rights, independent of judiciary, judicial review, impeachment of the president, removal of Supreme Court and High Court judges, and post of vice president. From Irish Constitution, we took directive principle of state policy, nomination of the Rajya Sabha member, method of election of the president. And from Canada Constitution, we take the federalism with the strong center and vested industrial power in the center, appointment of the state governor by the center, and the advisory judiciary of the Supreme Court. From Australian Constitution, we took the concurrent list, the freedom of trade, commerce, and intercourse, and the joint sitting of the two houses of the parliament. Then from Weimar Constitution of Germany, we took the suspension of fundamental rights during the emergency. Now from USSR or the Russia, we took the fundamental duties, the idea of justice, social economy, and political in preamble. And from French Constitution, we took the republic and ideas of liberty, equality, fraternity in the preamble. And from South Africa's Constitution, we took the procedure of amendment of the constitution and election of the members of Rajya Sabha, while from Japanese constitution we took the procedure of establishment by the law. So these are all the things which we have taken from different types of constitution in the Constitution of India. So we have completed this chapter as well, and thank you everyone for listening. And tomorrow I'll do some questions based on these on this chapter. All right, from M. Lakshmikant objective book at itself. And I hope this lecture was quite fruitful for you all. And thank you everyone for listening. And Jai Hind.